I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say it, so I've said it. In this episode, I'm going to be talking about how disability insurance carriers use the mental nervous policy limitation to their advantage and what you can do about it. The myths that disability insurance policyholders believe about mental, nervous, and substance abuse policy limitations, and the truth. The story of how one court upheld Unum's claim denial in a mold toxicity case under the mental nervous policy limitations. We're going to take a quick break, but when we come back, we'll begin. Stay tuned.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Ready to start? How disability insurance carriers use the mental nervous policy limitation to their advantage and what you can do about it. Two of the most common provisions in the disability insurance policy that will limit how long a claim will be paid for are the mental nervous disorder and substance abuse clauses. Now, these can be traps for the unwary disabled, including medical professionals. Many times, disability carriers will attempt to label a claim as a mental nervous claim as opposed to a physical claim, or they'll attempt to limit benefits based on the substance abuse provisions in a policy. So let's talk about how insurance companies weaponize these policy provisions. There is no uniform mental nervous disability policy limitation clause. So it's crucial that you get out your disability policy before you stop working and apply for your benefits, and read the policy from beginning to end. But in particular, read this provision closely. The provision may say that benefits are limited to just 2 years for any disability caused or contributed to because of a psychological condition. I call this the Monty Python wafer-thin clause of mental nervous disability. So let's say, for example, you have undergone back surgery because of a herniated disc. You've become depressed because of your continued pain. If your disability policy is broadly written, and you have this broadly written mental nervous clause, the carrier very well may deny your benefits after 2 years based on their claim that your disability is contributed to by your pain that in turn causes depression. I know that's strange, but the argument is if that depression contributes just so slightly to your overall disability, benefits are limited to just 2 years. Now, I think you need to know that in advance so that you can combat the disability carrier's mental nervous policy limitation game before your benefits are cut off. That's one provision that will truly rob you of your peace of mind. But what you also need to know is the disability policy may have another clause called the substance abuse clause. Now, that also is a tool that disability carriers will use to limit your disability benefits to just 2 years. Carriers will either wrap up a substance abuse policy limitation into the mental nervous disorder limitation, or they might have a separate substance abuse provision. So let's talk about how carriers weaponize these policy provisions and will deny claims for benefits. As I've said, many disability policies have mental nervous policy limitations. There's no uniform mental nervous disability policy limitation, and there is no uniform substance abuse limitation. So as I have said, it's really crucial that you get that disability policy out before you stop working and read it so you understand what limits there are in terms of your benefits and how you might be able to overcome that. So one of the first issues that we have in a case is substance abuse considered a psychological condition? Well, it might be if the policy incorporates into its definition of psychiatric conditions the DSM-4. Now, The DSM is a manual that has been developed and used by the American Psychological Association to diagnose mental conditions. And it's pretty broadly written. The disability carrier might invoke that mental nervous limitation if your disability is psychiatric in nature. And the DSM can define substance abuse disorder, including alcohol abuse and addiction, as a psychiatric issue, as is the manifestation of an addiction caused by a physical issue. So you've had that back surgery, you've become addicted to medication, and the carrier is saying, okay, look, we are going to apply the mental nervous policy limitation because your addiction is included in the definition of psychiatric conditions under the DSM. So you need to understand that in advance so that you can potentially combat a disability carrier's misuse of the mental nervous policy limitation. Now, I have to tell you, if that policy limitation is in there, specifically citing to the DSM, it's going to be problematic. And that's where I think you need the assistance of an experienced ERISA disability attorney to address how your individual case may be overcome, or how you may just be limited to those 2 years of benefits based on your personal circumstance. Now, the disability policy may also have this substance abuse policy rider, and that is either seen in combination with a specific psychiatric mental nervous limitation and condition that specifically has mention of the DSM, or you may see a very broad mental nervous policy limitation with no specific referral to the DSM, but you'll see a specific substance abuse policy limitation. Now, if your occupation involves burnout, stress, or you have access to addictive medication, I think that that's a concern. If you have an individual disability policy, you might want to add a substance abuse policy rider that will limit the impact of substance abuse issues in your case. And that's particularly true if you're an anesthesiologist, a pain management provider, an emergency room physician, a plastic surgeon, and even lawyers or stockbrokers, because these occupations do involve not only stress, but access to addictive medications and substances. This can be a minefield for policyholders. So if you're having psychological issues or substance abuse issues, I think you should be consulting, as I said, with an experienced ERISA disability attorney to know how your policy reads, what the pitfalls are, and potentially any limitations on your coverage. In the next segment, I'm going to do some myth busting, so stay tuned.